Welcome to the Compliance Council on Command webinar series. Today's topic is adjustable rate mortgage adjustment notices. I'm Jeff Anderson, an attorney at Dickinson Law that works with community banks with a focus on regulatory compliance. The adjustable rate mortgage rule is part of the Truth in Lending servicing rules that came out in January of 2014. So the servicing rules can be broken up into Truth in Lending rules and RESPA rules. This rule is in with the Truth in Lending rules, and it resides in 1026.20, where the existing adjustable rate mortgage notices rule is. Coverage of this rule, very broad, closed-end consumer loans secured by the consumer's principal dwelling where the APR may increase after consummation. There's no entity level exemption. So there's no small servicer exemption. So regardless of your size, if you have adjustable rate mortgages, the rules we'll discuss today will apply to that. So that APR may increase after consummation. Let's go into that in a bit more detail. So it only applies to adjustable rate mortgages that increase after consummation, where that increase is tied to an index or formula. So those loans that may increase after consummation, where it's not tied to an index, like a price level adjusted mortgage or a step rate mortgage, it's not going to apply to those. It's also not going to apply to rate adjustments that occur in a loan modification. So a loan modification, when that occurs, there can be adjustments to the rate, and it's after consummation of the loan, but it's generally not going to be tied to an index or a formula in any way. So it's not going to fall under this rule. Another key thing to keep in mind, go back a slide, is this only applies to arms secured by the consumer's principal dwelling. So it's not going to apply to those subordinate liens or those second home liens. It's only going to apply to those that are secured by the consumer's principal dwelling. So this rule isn't wholly new. There was already an existing rule prior to this rule that required notices prior to a rate adjustment on an ARM. And in the previous rule, you had to provide an annual notice every year on an ARM, regardless of whether an adjustment occurred. This rule makes some changes with those notices as far as timing and also content. So the rule prior to January 2014 required a notice of a rate adjustment 25 to 120 days before payment at the new level is due. The prior rule also required a notice every year. There was an annual notice regardless of whether a payment change occurred. So if you had a 5-1 ARM, nothing would happen in the first 5 years, but you were still required to send that notice every year. That annual notice is eliminated under this new rule. So you're no longer required to provide that annual notice. Your payment adjustment notice that was previously 25 to 120 days, that's retained under the new rule, but with slightly different timing. Then, in lieu of that annual notice, the new rule adds an initial adjustment notice, right? The CFPB couldn't just eliminate a useless notice and be done. They had to make sure that some other notice replaced it. And so they replaced that with a one-time initial adjustment notice. So let's talk about that initial adjustment notice first. That's the first thing you're going to be sending out for adjustable rate mortgages going forward. So this initial notice must be delivered or placed in the mail between 210 and 240 days before the first payment at the adjusted rate is due. So you have a 5-1 ARM. This is going to be sent out 210 to 240 days before that first adjustment that would occur after 5 years. So where do they come up with 210 and 240 days? They state in the preamble that they set it at essentially between 7 and 8 months because on average their studies find that that is the amount of time it takes to refinance a mortgage. So the CFPB seems to have something against ARMs, frankly. They don't particularly like them. You know, they classify them as a non-standard mortgage. So what they did is they wanted to ensure that consumers get enough time. They get a notice that gives them enough lead time to be able to refinance it before that adjustment occurs. So that's where this initial adjustment notice came from. That's why there's a 210 to 240 day period given notice prior to that first adjustment. So what happens if you have an ARM where the first adjustment occurs within 210 days after consummation? In that instance, the notice is provided at consummation. If you have that first adjustment within 210 days, you provide the initial adjustment notice at consummation. If it occurs outside of 210 days, then you're under this normal timing, for lack of a better term. I mean, the timing that's going to apply to your more standard 3-1, 5-1, 7-1 ARM products. Generally, with an initial adjustment rate notice, I mean, if you sit down and do the math, you're not going to know the new rate. So you're required to send out this initial adjustment notice, and it has certain content, and a big part of that content is, what is the rate that you're going to adjust to? Well, you're not going to know that in most instances. You're required to provide an estimate when you don't know the rate, when this notice is required to be sent out. You provide an estimate, you label it as an estimate, and you base that based on the appropriate index reported within 15 days prior to the disclosure date. You have the initial adjustment notice going out 210 to 240 days prior to the first adjustment. Then you have the payment adjustment notice. This is that adjustment notice that existed under the previous rule. So previously, this was, you provided it between 25 and 120 days prior to the first payment at the adjusted rate. Now they've changed that to between 60 and 120 days before the payment at the adjusted rate. One carve-out is it's not required for those loans where the first payment adjustment is within 210 days after consummation, and you've already disclosed in that instance with the initial rate adjustment at consummation. If you disclose the initial rate adjustment at consummation and it's not an estimate, you don't have to provide this one. You've already told them exactly what the rate is. Otherwise, if it was an estimate, then you need to provide this payment adjustment notice. The purpose of providing this payment adjustment notice prior to that first initial adjustment, when you've already provided them 7 to 8 months out an initial adjustment notice, is that that initial adjustment notice generally is going to be an estimate. And this payment adjustment notice will give the exact rate that they're adjusting to between 60 and 120 days before the first payment at the adjusted rate is due. So that's important. It's before the first payment at the adjusted rate is due, not before the actual adjustment. So you're going to have a date where the rates adjust, and then generally 30 days later, you're going to have a payment due that takes into account that rate adjustment. You count back from that payment due date, not the rate adjustment date. If you sit down and do the math, it has to be that way. Otherwise, it'd be impossible to get it out between 60 and 120 days with the standard 45-day look-back period. If you have a 45-day look-back period on your loans, then if you do the math, you have a 30-day billing cycle, 45-day look-back period. To get this out in time between that 60 and 120-day time frame, you'll likely have about a 2-week period to get this generated and get it sent out. If you have a look-back period of less than 45 days, then this is not going to be possible. The 60 and 120-day timing is generally not going to be possible. So they've grandfathered those loans in. So for adjustable rate mortgages that were originated prior to January 10th of 2015 that have a look-back period of less than 45 days, you can continue under that existing 25 to 120-day timing. They've grandfathered in not only loans made prior to the effective date of these rules, which was January 10th, 2014, but they're also grandfathering in loans made this year up through January 10th of 2015. So existing loans and loans that you make for the next year under that shorter look-back period, you can revert to that 25 to 120-day timing. They're grandfathering those in. Essentially, after January 10th, 2015, it's going to be very difficult, if not impossible, to originate any new adjustable rate mortgages that have a shorter look-back period than 45 days, because it's going to be really hard. If you have a 30-day look-back period, I don't see how you'd be able to get it out between 60 and 120 days. Now, maybe if you have something a bit more abnormal, like a 40-day look-back period, you might be able to fit it within there still. But otherwise, really where the CFPB is going is after January 10, 2015, that 45-day look-back period is likely going to become the market standard or their market minimum at the very least. So keep in mind that payment adjustment notice that's sent out 60 to 120 days generally, it's still required even after the initial rate adjustment. So prior to that first rate adjustment, the borrower is going to get an initial rate adjustment 210 to 240 days out, and then also a payment rate adjustment notice 60 to 120 days out. If the first adjustment is within 60 days of consummation and the rate disclosed at consummation was an estimate, then the notice has to be provided no less than 25 days before first payment at the adjusted level. So remember, these loans don't happen that often, but I wanted to make sure I covered it in the slides. If you provide the initial rate adjustment at consummation and it's not an estimate, you don't have to provide the payment adjustment notice at all. If it is an estimate, then that's where this timing kicks in if you're within 60 days of consummation and you provide it no less than 25 days before that first payment. The content of the notice, the content of the initial rate adjustment notice and the payment adjustment notice is very similar. There's just some differences regarding, for one, on the payment adjustment, you have information about past interest rate adjustments that you have to have on there. On an initial rate adjustment, there's not any past interest rate adjustments, so that information is going to fall off. So there are model sample forms available for these. This is a very model form-driven notice. So let's take a quick look at a couple documents here. This is a document that I've put together where I've just outlined the content of these disclosures. So what I've done, because they're so similar, to simplify the two and compare the two, I laid out here the content that's required for both disclosures is all on this document. And I've just noted, so in italics and underline, where there's content specific for the initial adjustment notice, and then I've provided in bold where there's content that's only required for the payment adjustment notice. So hopefully this is a helpful tool. And if you want a copy of this document, please just send me an email or give me a call. I'd be glad to email it out to you. Another document to look at, this is the model forms. So the model forms are provided here. There are a few depending on the circumstances, the type of loan it is. You'll see things are laid out in a table, things are laid out in a certain order with some model language. So the regulation provides that these disclosures have to be provided in the form of a table and in the same order as and with headings and format substantially similar to the model form. That means that you should really err on the side of making your disclosures as close as possible to the model form. You don't want to get to the point where you're arguing whether or not it's substantially similar. That's a very subjective standard. It explicitly states headings and format have to be substantially similar. There may be some instances where the text can change. Maybe you describe things a little bit differently, particular to your product or your institution. But you need to ensure that it's laid out in a table where a table is provided in the model and that the order and the format is substantially similar to these model forms. These notices have to be provided as a separate document. So they can be provided along with another notice. They could be provided in an envelope or as a separate attachment in an email that's sending other disclosures or documents, but it has to be its own document. It can't start on page 10 of a deposit statement disclosure. It has to be on its own separate document. Examples of the timing of how it works. So one example, if you have a loan that's consummated on January 1st of 2014, the first payment adjustment is 6 months out, June 1st of 2014. Here, you provide that initial adjustment notice at consummation because that first payment adjustment occurs within 210 days of consummation. How about the payment adjustment notice? If that initial adjustment notice, if you provide a rate there that's not an estimate, then you're not required to provide the payment adjustment notice. If the rate stated at consummation is an estimate, then you're looking at between February 1st and April 2nd of 2014 when you're sending that out. A more common example, if you consummate the loan on January 1st, first payment adjustment notice is November 1st of 2014. Now that initial rate adjustment notice is between April 5th and May 5th, and the payment adjustment notice would be provided between July 4th and September 2nd. So again, 210 to 240 days prior to the initial, the payment at the adjusted rate, and between 60 and 120 days prior to that first payment at the adjusted rate. So the compliance challenges that I've seen with this rule, you're very dependent on vendors generally. A lot of banks are very dependent on their vendors in generating these notices and often even in the timing in sending them out. So those are really the two issues that I see come up a lot. And I think it's important to ensure that you're getting these out in time and ensure that your vendor is getting them out in time and has procedures in place to ensure that they can send them out in time. I mean, vendor due diligence is a really big deal right now with regulators, and I think it's going to be a big deal with a lot of these mortgage rules. As examiners start to go in the second and third time and they start to see maybe some gaps and some violations, you're not going to be able to just point to the vendor and say, well, they messed it up, it was their fault. The examiners are going to be looking at you. Well, what's your due diligence when you had that when you hired that vendor? What ongoing due diligence did you do? So I really encourage you to review the forms you're using, and if there are differences between the model form, reach out to your vendors and force them to really explain those differences. Why is it still compliant? Get some assurances from them that it is still compliant. Again, the two documents I provided out there, the outline of the content of the two notices, and even the model forms, I'd be glad to email those out to you. Just shoot me an email or give me a telephone call. My phone and email is provided at the beginning of this presentation. Thank you.